I'm Giulio Coraggio.
And I'm Antonio Ravenna.
And today we're going to talk about the changes introduced by the Digital Omnibus to the AI Act.
And we're going to make it during the time of a coffee break. So, Giulio, what happened during the negotiation for the Digital Omnibus?
Well, the negotiations on the Digital Omnibus have been ongoing for more than a year now.
It's a very long time.
It's really a long time. Bear in mind that the next deadline for the EU AI Act is the 2nd of August of this year. So basically, companies were really in a stressful situation because they had an approaching deadline, they had the ongoing negotiations, they didn't know whether the deadline was going to be postponed, and they were in a sort of limbo.
So there was a lot of uncertainty.
Absolutely, and well, I would say the uncertainty is still there because we know that an agreement was reached. Apparently, the meeting ended at 4 in the morning, and that reminds us the negotiations on the EU AI Act. All of us were on X, Twitter, how it's called now, following the trilogue, the discussions, the negotiations between the Parliament, Commission and the Council on the text of the EU AI Act. And it's so surprising that after a year, they need to revise the text.
So let's get practical. What companies should be doing in the next, 3 months?
Well, they should be doing what they have been doing now, because the agreement that was reached on the Digital Omnibus is true that introduced, among others, an extension of the most approaching deadlines. At the same time, companies are already adopting AI solutions. The idea behind the Digital Omnibus changes was to avoid duplications. This was driven mainly by Germany because in relation to machinery, for instance, there was a risk that on top of the already burdensome obligations provided by machine-specific regulations, then there was an additional layer of obligation when AI was embedded into machines. And we know that for instance, the IoT industry within Germany is so strong, and that is normally powered up by AI. So basically, compliance was going to become an additional cost that is more manageable by very large corporations. And so basically, what had to become a competitive advantage for Europe, so regulating, I said, a common play field for everyone, was going to turn into a disadvantage because we know that the giant US corporations have more financial capabilities, so they can afford, on the one hand, larger fines, on the other hand, additional compliance obligations, while the smaller European companies don't have normally, well, obviously with some exceptions, the economy of scale that allows to absorb the additional compliance burden. And so basically, this was turning into a disadvantage for European companies.
So a lot of stratification, we can say.
Yeah, I mean, someone would say it's a useless stratification because the type of certifications that are already provided by sector-specific legislation, like let's think about the life sciences sector. It's really heavily regulated, and introducing an additional obligation of certification for high-risk AI systems was gonna first of all delay the entrance into the market, secondly increase the costs, and in a nutshell was turning into less effective services for the European economy, and at the same time a more reduced resources, also to become more competitive globally. What I can see, it's the agreement on the digital omnibus is the first time, as far as I remember, that Europe understood that they need to have an approach that is sort of market driven. They need to understand that regulations cannot work in silos. So I regulate this piece of a machine, I regulate this other piece, and it's on companies to put all the pieces together, while Europe now understood that they need to put themselves into the shoes of European companies that have, when they put all the pieces together, need to then offer their services on the market, and they need to have a more kind of market-driven approach. They need to understand when these layers of legislation become too burdensome, they are turning into a disadvantage, while I'm not saying that the US approach of total deregulation should be the rule, but a right balance should understand when regulating is necessary and when is excessive. So it's the first time that there is this sort of acknowledgement by Europe. There could be definitely a turning point. I mean, we see the same with the GDPR, that is so much principle based. Sometimes I always say that privacy rights are used by individuals in an abusive manner at the moment to damage, for instance, their employers, to get some money from their suppliers, while it's true that there should be an ethical approach to business, but then basically if the economy is not growing, everyone is paying more and everyone is having a worse living.
So what's really changed with this digital omnibus in the AI sphere?
Well, first of all, we were saying before, duplications are reduced. So when there is a sector-specific legislation, then the additional layer of obligations under the EU AI Act is not removed totally, but is considerably reduced. Secondly, the deadlines of August of this year are postponed to 2027, the end of 2027, and for AI solutions that have sector-specific legislation to 2028. I mean, this all shows that the legislator understood that the economy wasn't ready to afford this legislation. Let's bear in mind that the EU AI Act is the first legislation that came into place before the hype of the technology, because we're still at the infancy of this legislation. So let's see, because my big question, and it's maybe a question also for the audience, having a legislation that applies to a technology that is so evolving in a very quickly manner and will come into place in 2-3 years, are we really sure that this legislation can properly fit with a technology that in 2-3 years might be considerably different? Just the last message, if I can, Antonio. The worst strategy for a business would be to say, okay, now I have more time, I can pause. I mean, let's bear in mind that companies' operations have considerably changed over the last 12 months because AI is now embedded their operations, and it will be more and more. If you think that you have more time and you can adopt solutions without doing a compliance assessment that should have a sort of a long-term view, then you risk that once this technology is an essential component of your operations, you realize that these solutions are not compliant, and just removing that piece of technology from your operations or making that compliant would be so expensive. So it's not that the message from the EU is not that you have more time, you can take a break. You have more time to become compliant because they realize it takes longer.
So in a nutshell, it is a really, really big news for everyone.
Well, it's a big news. I remember what happened with the GDPR, that we knew it was coming, but then we still remember the long nights of May 2018. This cannot happen now because, well, first of all, some provisions of the EU AI Act are already in place, and secondly, the changing the direction, changing the technology at a later stage might be in some cases not affordable.
So thank you, Giulio. This is fantastic news for every company, and it is very, very clear that they should not just rest on this news, but continue to acting through the implementation of the AI Act.
You know, sometimes clients say that I'm hyperactive. Well, also my kids say that. Yeah, I mean, we're here to help, and thank you, Antonio. Arrivederci.